guys! So welcome back to my channel. So for today's video, we are going to talk about Article 5 of the Revised Penal Code. So basically, Article 5 talks about the duty of the courts in connection with acts which should be repressed but which are not covered by the law and in cases of excessive penalties. So let us first focus on that statement. So in connection with acts which should be repressed. So repress means to control. Yes, to control. So, in connection with acts which should be repressed refers to those acts that needs to be controlled or acts that needs to be punished but which are not covered by the law. But even though these acts are punishable, it was not defined and it was not penalized under a revised penal code. So basically, this act, even though it really needs to be punished, but it was not defined on the revised penal code, so we cannot consider that as a crime or a felonious act. Then, the second duty of the court is in cases of excessive penalties. So, this is understandable.
Yung mga kaso na yung penalty nila is sobra-sobra. So, what are the duties of the courts with this, in these two situations? So, yun yung nasa Article 5.
So now, let us first read the first paragraph of Article 5. So whenever a court has knowledge of any act which it may deem proper to repress and which is not punishable by law, it shall render the proper decision and shall report to the Chief Executive through the Department of Justice the reasons which induce the court to believe that said act should be made the subject for penal legislation. So, what is our paragraph 1 of Article 5 talks about? So, it talks about the first duty of the courts. Again, those in connection with those acts which should be repressed but which are not covered by the law.
So, yun yung tinutukoy sa paragraph 1 ng Article 5.
So, when an act is clearly reprehensible but there is no law punishing it, the court must render the proper decision. And that decision is to dismiss the case. So, ito yung sinasabi ng paragraph 1 na it shall render the proper decision. So, the proper decision that was stated in Article 5 is to dismiss the case. Okay? Because even though that certain act needs to be punished, but it was not again penalized under the revised penal code, so that act cannot be considered a crime. So the court must render a proper decision, and that decision is to dismiss the case. So the basis for paragraph 1 of Article 5 of the revised penal code is the legal maxim of nullum crimen nulla pena sine lege. Tama ba yung pag-pronounce? So, it means that when there is no crime, when there is no crime, there is no law punishing it. So, ayun yung first duty ng court. So, again, if merong crime or if merong act na punishable pero hindi siya na-define under the revised penal code and hindi siya na-penalize doon, it cannot be considered a crime. And since it is not a crime, so the court must render a proper decision. And that decision is to dismiss the case. Because again, according to the legal maxim, there is no crime when there is no law punishing it. So, ayun. But the duty of the court does not end there. So,
hindi doon nagtatapos yung duty ng court. So, after niya ma-dismiss ng case, so, hindi pa doon nagtatapos. No? Ulit-ulit.
So, the court has to recommend to the President through the Department of Justice that the act must be made a subject of a penal legislation so that the reprehensible act will be covered by a law which imposes a penalty for the commission thereof. So after ma-dismiss nung case, yung court is magre-recommend siya sa President through the Department of Justice.
So, pinaagi sa Department of Justice, that act, so kato siya nga act, katong dili punishable under the revised penal code, iyatong i-recommend sa President, pinaagi sa Department of Justice, na kato siya is subject for penal legislation or subject for making a new law that would punish that act. So para in the next situation na naana po yung lahi nga tao nga mo-commit adto na crime, so punishable na siya. Okay? So mo na siya ang ipasabot sa paragraph 1 sa Article 5.
So, para maintindihan natin ng maigi yung paragraph 1, char, Tagalog. So, in order for us to understand well the paragraph 1 of Article 5, so let us have the illustration or example. So, for example, Juan discovered that when a durian seed is dried and powdered and mixed with sugar, it will produce a substance which has similar effects with shabu, which is a prohibited drug, but the substance is not of those included under RA 9165. So, supposing si Pedro to, no? So, supposing si Pedro is nadakpan siya nga nagamit og namaligya adtong katong iyahang gi-process nga durian seed. So, the question is he criminally liable? So, si Pedro discovered that a durian seed can be processed and used, which has this similar effect of a shabu or drugs, which is prohibited under RA 9165. So, but kato siya nga substance, wala siya na-include dadto sa RA 9165. So, the question is, if Pedro was caught processing or using or selling the same thing, is he criminally liable? So, the answer is no. This is according to paragraph 1 of Article 5 of the Revised Penal Code, because there is no law punishing the selling and possession of a powdered durian seed mixed with sugar. So, the court must render a proper decision, which is to dismiss the case and recommend to the Chief Executive through the Department of Justice that a legislation be passed defining and penalizing the act.
Para sa sunod nga naanapoy mo himo ato nga act, so punishable na siya under a revised penal code. So mo to siya ang nasa paragraph 1 of Article 5 of the revised penal.
So again, sa first paragraph sa Article 5, it contemplates a trial of a criminal case which requires the following. Number 1, that the act committed by the accused appears not punishable by any law. Number 2, but the court deems it proper to repress such act. Number 3, in that case, the court must render the proper decision by dismissing the case and acquitting the accused. And the last one, number 4, the judges must then make a report to the Chief Executive through the Secretary of Justice stating the reasons which induced him to believe that said act should be made the subject of penal legislation. So now let us proceed to paragraph 2 of Article 5. So, paragraph 2. So, in the same way, the court shall submit to the Chief Executive through the Department of Justice such statement as may be deemed proper without suspending the execution of the sentence when a strict enforcement of the provisions of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. So now let us understand paragraph 2. Kung yung paragraph 1, it refers to the legal maxim na when there is no crime, when there is no law punishing it. Yung paragraph 2 naman is nag-refer siya doon sa legal maxim na dura lex sed lex. If I'm not mistaken. So it means that the law may be harsh but it's still the law. So in paragraph 2, Article 5, so when there is a strict and proper adherence to the to the law would result to a clearly excessive penalty, the judge must nevertheless impose the penalty irrespective of his personal belief and reservation and without suspending the execution of the same, recommended to the Chief Executive through the Department of Justice that the penalty be reduced or commuted or that the convict be granted executive clemency, whichever is proper under the circumstances. So, itong paragraph 2 is that, so if there is a if there is a circumstances, so, and there is a strict and proper adherence to the law, and it would result to a clearly excessive penalties. Yun ba, sobra-sobra yung penalties or punishment ay papataw sa isang case, so the judge must nevertheless impose the penalties. So, even though yung judge feel niya is mali yung punishment na to, kasi excessive siya, sobra-sobra naman, and dapat pababain. So, for example, death penalty. So, example, yung tao, nagnakaw siya, tapos, example lang to ha. So, exage lang to na example. So, for example, yung tao is nagnakaw siya, and then yung punishment ng pagnanakaw is death penalty, and then the judge think that death penalty is a very excessive punishment, or sobra-sobra yung punishment niya, he will still render the punishment, so irrespective with the judge personal belief.
So that, so mao to siya. So even though excessive ang penalty sa pananaw sa judge, dapat to siya i-render. Mao na siya iyang trabaho, okay?
It will still impose the penalty given on that specific crime or act, no? And then, so, muna siya ang trabaho sa court. So, muna paragraph 2. But again, dili lang dara mahuman ang trabaho sa court. It would not end there because after that, after imposing that penalty, even how excessive it was, so, the judge or the court would recommend to the chief executive through the Department of Justice that said penalty or punishment must be reduced.
So sa first paragraph is i-recommend sa chief executive to the Department of Justice na dapat magawa tayo ng bagong law that penalizes us. So, in paragraph 2 naman is nag-recommend yung court sa chief executive through the secretary of through the Department of Justice na itong penalty na to is sobra-sobra and we need to reduce it because dili siya justifiable. So muna siya ang duty sa court sa ikaduhan na paragraph sa Article 5.
So, the second paragraph of Article 5 requires that number 1, the court after trial finds the accused guilty. Number 2, that the penalty provided by law and which the court imposes for the crime committed appears to be clearly excessive because number 1, the accused acted with lesser degree of malice and or number 2, there is no injury or the injury caused is of lesser gravity. And then number 3, that the court should not suspend the execution of the sentence. And then number 4 is the judge should submit a statement to the Chief of Justice through the Secretary to the Chief Executive through the Secretary of Justice recommending executive clemency. So again, yung paragraph 2 is there is a certain crime and then yung punishment niya is sobra-sobra. So even though according to the judge opinion na dapat hindi niya i-render yung specific punishment na provided ng law kasi sobra-sobra yon, the duty of the court is he must still impose that penalty to that crime even though in his opinion dapat dili to siya maokay, sobra-sobra. And then after niya ma-impose ang crime, tapos dapat i-execute niya ang sentence, no? Dili niya i-suspend ang sentence. The court must not suspend the sentence just because he thinks or his opinions that that crime is not suitable for that specific crime. So, dapat continue pa rin yung execution. And then, afterwards, the court should recommend to the Chief Executive through the Department of Justice na pababain or, to amend that punishment na dapat pababain siya kasi excessive lang. Sobra-sobra. So now let's take the examples of the accused acting with lesser degree of malice. So this is the case of People versus Monleon. So in this case, the accused maltreated his wife in his inebriated state because she prevented him from whipping their negligent son, and the maltreatment inflicted by the accused was a proximate cause of her death. So the Supreme Court applied the Article 5 of the Revised Penal Code, considering that the accused had no intent to kill his wife and that her death might be hastened by lack of appropriate medical attendance or her weak constitution. So the penalty of reclusion perpetua prescribed by law for the crime committed appears to be excessive. So
diba excessive siya? Kasi the reason naman na napatay niya yung wife niya is because na-prevent lang siya para hindi saktan yung anak nila. Tapos, unfortunately, namatay ang iyang wife. Pero wala siya intention na at yun, diba? Then, ang punishment agad kasi is excessive. So, this is the example of the accused acting with lesser degree of malice.
And the next one is example of injury caused is a lesser gravity. So this is based on the case of People versus Acbangin. Yes. So the victim, a 4-year-old child, was brought by the accused to the house of a certain Juanita New. The accused initially denied knowing where the victim was, but the next day told the victim's grandmother that the victim was at New house. The accused accompanied with the victim's father and the police officers to New house and found the victim well dressed and smiling. So the accused was convicted of kidnapping and serious illegal detention and sentenced to reclusion perpetua. So the ruling is that we agree with the trial court that a strict application of Article 267 of the Revised Penal Code would be too harsh, taking into consideration that the minimal injury caused by the offense. We agree that the accused be recommended to the Chief Executive for the possible exercise of his pardoning power pursuant to Article 5 of the Revised Penal Code. So we recommend to His Excellency, the President of the Philippines, through the Secretary of Justice, the grant to accused of either a commutation of sentence to an indeterminate penalty of prison correctional to prison mayor or executive clemency. And then let's have the example of a total absence of injury. So this is based from the case of People versus Cabagsan. So the defendant chief of police altered and falsified the municipal police blotter and the book of records of arrest and the return of the warrant of the arrest and the bail bond of a person charged with qualified seduction so as to make them show that the said person was arrested and gave bond on the 13th day of September 1930, whereas in the truth and in fact as records showed before said falsification, the person was arrested and released on bond on the 6th day of September 1930, and that the defendant, Justice of the Peace, conspired and cooperated with his co-defendant in making said falsification in order to meet the administrative charges then pending against him. So in other words, those falsifications were committed to make it proper that there was no delay in the preliminary investigation conducted by the Justice of the Peace for qualified seduction. So in this case, there is apparent lack of malice and total absence of injury. So penalties are not excessive when intended to enforce a public policy. So number one is that the rampant lawlessness against property, person, and even the very security of the government, directly traceable in large measure to promiscuous carrying and use of powerful weapons, justify imprisonment which in normal circumstances might appear excessive. So this is based on the case of People versus Estoista, 93 Phil 647654. And number two, with regard to the fine of 5,000 pesos imposed by the courts for selling a can of powdered cream milk for 2 pesos and 20 centavos when the selling price for it was 1 peso and 80 centavos. So it should be considered that the Congress, though it necessary to repress profiteering, with a heavy fine so that dealers would not take advantage of the critical condition to make unusual profit. So this is based on the case of People versus Tiu Ua 96 Phil 7387. So courts have the duty to apply the penalty as provided by the law. So a trial judge expressed in his decision his view against the wisdom of the death penalty and refused to impose it. Ruling is that it is the duty of the judicial officers to respect and apply the law regardless of their private opinions. So it is a well-settled rule that the courts are not concerned with the wisdom, efficacy, or morality of laws. So the question falls exclusively within the province of the legislator, which enacts them, and the chief executive, who approves or vetoes them. The only function of the judiciary is to interpret the laws, and if not in disharmony with the Constitution, to apply them. So this was referred to the case of People versus Limaco. So a trial judge sentenced the accused to life imprisonment, although the commission of the crime of robbery with homicide was attended by the aggravating circumstances of nocturnity and in band in the view of the attitude of the chief executive on death penalty. So the ruling is that the courts should interpret and apply the law as they find them on the statute books, regardless of the manner their judgments are executed and implemented by the executive department. So you will learn how to construct or how to construe a statute or how to interpret them in your subject on statutory. So again, for paragraph 2, so the duty of the courts is to apply the law, disregarding their feelings of sympathy or pity to an accused. Again, this is a based from the Latin maxim of dura lex sed lex. The law may be harsh, but it's still the law. So the remedy is elsewhere a clemency from the executive or the amendment of the law by the legislative. But surely at this point, this court cannot apply the law. So this is the ruling in the case of People versus AMigo.
So that ends my discussion about Article 5. So the point, ang point lang atong sabon sa Article 5 is, it talks about the duty of the court. Number 1, katong mga acts na punishable, pero wala siya gi-define sa revised penal code. So ang duty sa court, ana, is i-dismiss niya ang kaso, and then i-recommend niya dito sa chief executive na dapat maghimo og new legislation para nga kaso. And then the second one is that in cases of excessive penalties. So kung pagtuo sa judge na excessive ang penalties, iyan na kung i-apply regardless of his opinion or iyang kaluoy na na-feel towards the accused. And the remedy, ana, is i-amend to nga punishment para dili na kayo siya harsh.
So that ends my video. So that ends my video. Thank you for watching.